My name is David Carter, Speaker of the House. As you watch question period, you will notice that there are many bits of paper floating around the Speaker and his desk. Oftentimes there are notes being sent to the Speaker from the opposition benches as well as from the government benches with questions dealing with procedure or with points of order that might come up later on in the day's proceedings. Other papers are there, such as the front pages of bills which are to be introduced so that the Speaker can read the correct title of the bill together with the name of the sponsor from whichever constituency. So it is that the Speaker almost has to be something of a juggler to deal with all the bits of paper and the reference volumes that are necessary to keep the proceedings of the House in order. Let us pray. At the beginning of this week, we ask you, Father, to renew and strengthen us the awareness of our duty and privilege as members of this legislature. We ask you also in your divine providence to bless and protect the Assembly and the province we are elected to serve. Amen.
Introduction of visitors. Presenting petitions. Reading and receiving petitions. Presenting reports by standing and special committees. Notices of motions. Introduction of bills. Tabling returns and reports.
Mr. Speaker, I'm pleased to file several reports today. The first is a report pursuant to Section 31(6) of the Legislative Assembly Act for March 31st, 87. A report pursuant to 43.4 of the Legislative Assembly Act for March 31st, 87. And Alberta Municipal Financing Corporation Annual Statement for the year 1987.
Introduction of special guests.
Member for Innisfil.
Mr. Speaker, it's my pleasure to introduce to you and to members of the Assembly 20 students from the Salem Christian Academy. They are accompanied by their principal, Mrs. Carol Loney, and 2 bus drivers, George Loney and John Darlington. They are seated in the members gallery, and I would ask you to rise and get the warm welcome of the Assembly. Thank you.
Minister of Culture and Multiculturalism.
Mr. Speaker, on behalf of my colleague, the Minister of Tourism, the member for Wetaskiwin and Leduc, I'm pleased to introduce to you and through you to the members of the Assembly 25 bright young people from the Leduc Junior High School, grade 8 class. They're accompanied by their teachers, Mr. Greg Fedor and Ms. Jadir Hapienko. They're sitting in the public gallery. If they would rise and receive the Assembly, warm welcome.
The Associate Minister of Agriculture.
Mr. Speaker, it's my pleasure to introduce to you and through you to the members of the Legislative Assembly 80 grade 6 students from the Rivervale School in Devon. They're accompanied by their teachers, Mrs. J. Watson, Mrs. J. Nicholson, and Mr. R. Pateski, and parent Mrs. Greenwood. They're in both the public and members gallery, and I'd ask them to rise and receive the traditional warm welcome.
Member for Dunvegan.
Mr. Speaker, it is my pleasure and privilege to introduce to you and through you to Mr. Dave Allison. Dave is Superintendent of the Fairview School Division. He is accompanied today by his daughter, Darylyn. I would ask them to rise and receive the warm welcome of the Assembly.
Ministerial statements. Oral question period.
Mr. Speaker, I'd like to direct this question to the Premier. Mr. Speaker, in 1984, the Assistant Deputy Minister of Consumer and Corporate Affairs, Mr. Darwish, pleaded with the government in a very urgent way to take action to protect innocent investors in the two failed investment companies of the Principal Group. My question to the Premier, does the Premier intend to answer why warnings were ignored by this government for 3 years while more investment contracts were sold to an unsuspecting public?
Thank you, Mr. Premier. Chair has been growing more and more concerned day by day by the attempts to be asking questions on an issue that is clearly sub judice, no matter which interpretation one wants to refer to, whether it's Standing Order 23G subsection 1 or the relevant quotations within Beauchesne. And the responsibility is clearly upon both the asker of the question as well as the person who the question has been addressed to. Let's watch it.
Answer to the question. If he doesn't want to answer it, that's fine. This has to do with a public document. It has nothing to do with the code inquiry, and the people of Alberta want to know that. Do not hide behind this code inquiry.
Next question.
Mr. Speaker, there's nobody hiding behind the code inquiry. As a matter of fact, this government, as the reason there is, we made sure that there would be a code inquiry. We've also made sure by an order that there would be an inquiry by the Ombudsman. We've also made sure that all members of the government are free to be called to speak at the inquiry. I've talked to Her Honour, the Lieutenant Governor requested, and she's agreed to remove the normal oath of secrecy that members of Cabinet must observe. All files and records are available. There is nobody hiding at all behind the code inquiry. And obviously this is the third time the question's been asked in our legislature. You've now responded in the way you have. To the honourable member, I think he should observe your comments.
Mr. Speaker, it's not up to the Premier to decide this, Mr. Speaker.
That's right.
And my question is to the Premier, along with this, a public document from Mr. Darwish had also talked about the Trustees Act, Mr. Speaker, and he went on to suggest that this company should not be allowed, clearly back in 1984, to continue as a trustee investment. Does the Premier intend to answer for this government why it was not removed by the Cabinet at this time?
Thank you. The chair passes on to the second main question, Leader of the Opposition.
Mr. Speaker, on a point of order, I will move on to my third question now, if you're going to rule that one out, and the third one is definitely in order. Mr. Speaker, my question... no, Mr. Speaker. Mr. Speaker, that's all right. They can continue to hide and laugh, but people in principle want to know. My question to the Premier, does the Premier have any explanation why it is even today, Mr. Speaker, that First Investors Corporation remains on the list as an approved corporation for investments under the Trustee Act?
Mr. Speaker, First Investors is part of the code inquiry, and I don't feel I should deal with the matter.
The question, the last question.
Nothing to do, even this, today that this company remains. And my question is, why is this company still listed under the Trustees Act today, at this particular time? Not even you can hide under the code inquiry from that.
Mr. Speaker, obviously, as I said before, no one is trying to hide behind the code inquiry. That company is currently before the inquiry, and I repeat that it makes no sense to have a public inquiry ordered by the courts and then try to have the opposition in some way try and do the same thing in the legislature.
Thank you. Edmonton Goldbar.
Supplementary, Mr. Speaker, to the Premier. Are there any circumstances, Mr. Premier, under which the government would compensate investors before the completion and report of the inquiry?
Well, that's a very speculative question, Mr. Speaker. I can't guess at a bunch of circumstances.
A point of order on the previous discussion. After question period, Mr. Speaker.
That's a go, yes.
And I'd like to direct, even though the Premier has selective hearing, wouldn't even answer the last ones, but I'd like to direct my second question, Mr. Speaker, to the member for Edmonton Highlands.
Pardon me? Mr. Speaker, I'd like to ask the Premier about his recent trip home from Palm Springs, where it was discovered, I guess, this weekend that he was, for some reason, able to catch a personal flight thanks to his buddies at Nova Corporation. Now, I don't want to ask him about the circumstances that required him to come home. That's his business. But I do want to ask the Premier if he's not concerned that public perception is that the Premier is taking advantage of his political office by not waiting in queue like everybody else, that he's able to hop on a flight that's brought specially...
Is that the question? We've had 5 sentences so far.
No, you've had 2 carefully constructed compound sentence structures, the latter of which included a question, Mr. Speaker.
Please. Order, please. Order.
Mr. Speaker, I will speak only briefly to this because it is a matter of very personal matter. But yes, there is always some concern when something happens like this, where in my case, I am able to obtain assistance on a very urgent matter of a personal nature. And of course, I never, ever do it. I would never do it. In this case, I had commercial passage there and back. Something did arise that was of a very personal nature. I asked my staff if there was any way I could get on any flights back. I was unable to, but I did have to come back, and I appreciate very much that Nova were able to help me come back. It worked.
Yeah, supplementary to the Premier. One understands, of course, that sometimes those circumstances dictate, but most people don't have the cozy relationship with Nova. Given that the government has more than $100 million invested in Nova, is the Premier not concerned that that the public is going to view this as very special, uncommonly special treatment, that Nova isn't going to bite the hand that feeds it?
Well, Mr. Speaker, I think the public have a much fairer appreciation of things than that.
Right.
He should have been at my house last night when the phone was ringing. Supplementary question to the Premier then is he now prepared to offer to pay Nova personally, as it was personal business that brought the Premier back to Alberta?
Mr. Speaker, that is impossible to do. It's illegal for Nova to receive payment for such a flight.
Final supplementary question, Mr. Speaker. Will the Premier make attempts to do what his predecessor did when he found himself in this awkward situation and find a way to straighten it up, find a way to pay Nova so that people don't believe he's taking advantage of his office?
Mr. Speaker, first of all, as I said earlier, I don't believe people believe that at all. As a matter of fact, the previous situation of Premier Lougheed, I guess, being referred to, was something to do with a commercial airline where paying for it was something that was simple to do. There is absolutely no comparison between these two cases.
Supplementary, Westlock Sturgeon.
Mr. Speaker, it's further to the Premier. I'm sure many of us have experienced family emergencies, and I can understand the Premier having to make use of a possible plane, but knowing, in fact, that this corporation maybe gets $8 out of every 10 it makes out of regulations made by this province. And I have checked the Department of Transport. I think it's...
Please, honourable member. Order, please, honourable member. Honourable member, it's all in the same paragraph. Could we have the question, please?
It's what you call a Diefenbaker sentence, Mr. Speaker. I thought you'd be very familiar with it. Yeah. I have checked the Department of Transport, and you can indeed pay. They cannot charge you, yes, but you can indeed pay. Very fair.
Honourable member, the question, please. The question.
Would you offer to pay?
Would you send Nova a check? Whether they put it in their ear or donate it to charity, it doesn't matter, but it looks good for all politicians if you would send them a check. It is not illegal.
Mr. Speaker, the only thing that looks bad for politicians is when politicians like the opposition try in some cheap political way to take advantage of something like this.
Member for Little Bow.
Supplementary question to the Premier, and it's a general question with regards to matters such as this. Could the Premier indicate what written or unwritten guidelines or policy is in place in reference to items such as this that may be encountered by the ministers of his cabinet?
Mr. Speaker, it's virtually impossible to try and write all of the circumstances that might conduct themselves and lead to a decision like this. Basically, I think the word is emergency. If in judgment there is an emergency and that emergency can be helped in some way, that's the way people are in Alberta, whether that's a corporate citizen or an individual citizen. We all try to help each other.
Chair recognizes Westlock Sturgeon.
Thank you, Mr. Speaker. These are two half-Diefenbaker sentences. This first one is it's to the Premier, Mr. Speaker, and possibly the Minister of Environment. View of the huge jump in cost, Mr. Premier, of disposing of hazardous waste, anywhere from 24 times up to some areas in dry cleaning 1,700 times, and to meet the cost of handling hazardous waste. And the Environment Minister has correctly said that safety is more important than money. And in view of this being a public service, would the Minister, or would the Premier now have his cabinet to reconsider the whole idea of having a private entrepreneur in here making a huge profit of what is a public service, and would he consider going back and asking the government to buy it out and operate it as a public service without this private entrepreneur in there?
No, Mr. Speaker.
Supplementary question then. This may be more to the Minister of Environment. In view of the fact that we're going to continue to reward someone 60% of the profits and that, and we want to get the hazardous waste to the plant, would the Minister consider a tax on the sale of hazardous materials before they are used, with giving back a rebate as a system of in order to ensure that waste will be turned over rather than hidden in the alleys and in the sewers of this province?
Mr. Speaker, in the original question forwarded to the Premier by the Leader of the Liberal Opposition, the member quoted some figures that are completely unknown to me. My understanding is of the new waste regulations that have come into effect in Alberta as of April 1, 1988, which are the most stringent regulations to be found anywhere, that in terms of looking at all of the disposers and the creators of waste, that in fact the increase in costs will be in the neighbourhood of 3/4 of 1% to 2% of gross volume sales. So I would ask the member to kindly give me examples of increases in the neighbourhood of 2,400% or 3,000%. I know that he may have read an article in a daily newspaper out of Calgary last week which contained many erroneous statements, and that may be the reason for his question today.
Mr. Speaker, I will fight off the urge to answer his question and continue with my questions, and view of the fact that he has not answered the first one, Mr. Speaker. There is no question, and I think the Speaker, the Minister has been right in forbidding much more being dumped into dumps, but we have to somehow or another make sure that this material is being delivered to the hazardous waste plant. Would he then consider some form of subsidies for hauling some particular materials in order to make sure we clear out the 30,000 tons of waste that appear to be in this province, hidden in different storage spots?
Mr. Speaker, the cost of the Alberta Special Waste Management Corporation, Swan Hills, is approximately $50 million. Those $50 million have been put forward by the taxpayers of the province of Alberta. So in one way, one could make the argument that the public, the taxpayer in our province, is already invested in this particular system. I should also like to point out as well, Mr. Speaker, that there are 4 other alternatives to the disposal of hazardous waste in our province other than the directing of those hazardous waste to Swan Hills that would not require anybody to dump these wastes in back alleys or in other locations throughout our province, first of all, waste can be recycled. And under the regulations we've had and the identification of the 1,000 hazardous or toxic waste we have in this province, we've allowed a provision. And we want to stimulate a recycling industry in this province. So some of these wastes can be taken to a recycler. Second alternative, Mr. Speaker, is we have created in this province in Alberta waste exchange, which is a stock market, so that a creator of waste can be put in touch with someone who wants the waste. And that particular waste exchange operates with the Alberta Research Council, which is a very bona fide research facility, a scientific research facility in our province. And it might not cost anyone any money. A third alternative, of course, is a provision under waste regulations to allow a generator of waste to dispose of those wastes on site, providing they get authority from Alberta Environment for the particular plant that they want. And the fourth alternative.
Thank you, Honourable Member. Perhaps a supplementary.
Last supplementary. Thank you, Mr. Speaker. You are probably you're able to stop more of the hazardous waste floating around here than anybody's been able to. Mr. Speaker, could we go on to another step? The last question. Is the minister aware that the Alberta Special Waste Management Corporation, when you dial their number here in Edmonton and say that you are a householder and have hazardous waste to get rid of, that they do not know what to do with it? They tell you to hold on to it. They don't know where to deliver it.
Well, Mr. Speaker, we made it very clear in the regulations that we passed, this government passed on December 17, 1987, and that came into effect on April 1, 1988, that there was a provision for small generators, i.e. households, to be exempted from this particular regulation in point. Mr. Speaker, I think it's extremely important that when Mrs. Taylor in her home decides that she has to dispose of the aerosol cans that Mr. Taylor uses in his homes, that she need not contact the Alberta Special Waste Management Corporation, and hazardous waste would include aerosol containers. She might dutifully just take them, put them in a black plastic bag, and await further news as we go through 1988 to see how we will determine that small generators, i.e. households in this province, would be asked to deal with hazardous waste. We're first of all going to deal with the massive, major amount that we have in this province that have come into effect April 1, 1988, and we will deal with the households of this province as we go through 1988.
The member for Edmonton, Glengarry.
Thank you, Mr. Speaker. For the Premier, in view of the many millions of taxpayers' dollars that are being used to subsidize disposal of hazardous waste in the province, would the Premier recognize that it would be much better to use those millions of dollars to subsidize the disposal itself rather than use them to subsidize the profits of the government's friends in Bow Valley Resource Services?
Mr. Speaker, it's obvious the honourable members don't like the fact that Alberta is leading the world in disposal of hazardous wastes. When we opened that plant up there, people came from all over the world, and they were envious of what we have here in Alberta. And I know that the honourable members don't like positive things like that, and I know they're going to try and somehow make people think negatively of those type of first-class operations in this province. But we are going to protect the people of Alberta, and we're going to do it within the kind of conservative principles that we believe in, and if they don't like it, that's tough.
Mr. Speaker, my question is to the Associate Minister of Tuesday last. The Minister was made aware of a submission by the Association of Municipal Districts and Counties of the province of Alberta, which indicated their concern about the Alberta Agricultural Development Corporation policy, specifically with regards to a leaseback arrangement for young farmers. Could the Minister indicate what consideration she has made of that resolution that was passed unanimously by the Association, by all member counties and municipal districts? Has the Minister determined what to do with regards to their submission?
The question has been asked by Associate Minister.
Thank you, Mr. Chairman. Yes, I was made aware of the, Speaker, sorry. I was made aware of the resolution that was passed, and I am looking at it along with a lot of other suggestions that I've had this weekend at the very valuable Progressive Conservative Conference which we had. And
better go, Cheryl.
good one.
and which we have a clear indication of how successful it was by the total ignoring of it by the opposition parties.
Mr. Speaker, supplementary question to the Minister. Could the Minister indicate when she will respond to that resolution? Will it be this week?
Two questions there, so give two answers. We'll go on.
Mr. Speaker, I may respond this week. I can understand the member's consternation, and I'm kind of tired of being the good guy in this because...
How about good girl?
Because
How good are you?
the member raised on a point of privilege where he'd helped people fill out forms, and on the November the 13th, 1981. On October the 16th, 1981, the member said, just down the road, a father and 3 sons. The sons want to get into farming. We've been working for over a year trying to get ADC loans to help them, but to no avail. 4 or 5 miles down the road, another farmer I helped get in business. Mr. Speaker, the member may have given some people bad advice, and I can understand him squirming about their problems.
Supplementary question to the Minister. The Minister may get smart with regards to the answers, and I've helped young farmers then, and I'm intending to help them now. And there's a lot of rural people out there that are waiting for answers with this Minister that's not doing their job. Could the Minister indicate? And we must have a response in a positive way this week. When will her proposals be presented to this legislature in a ministerial announcement so that the public knows that the government of this province is doing something for agriculture today?
Mr. Speaker, as I've indicated on a number of occasions, as soon as I have a final decision on any new propositions or policies which I have, I will be presenting them to the legislature.
Westlock Sturgeon.
Speaker, the Associate Minister is a good guy. Sweeney Todd is my godmother, but could I put...
Supplementary questions is questions, not comments, sir. Please.
My question is to the Premier. Isn't it not rather obvious that what the government is doing is trying to hasten the vacation from the land of our small farmers, our young farmers, and has no intention of trying to keep our farming and rural communities going? His idea is to move them to the city and put them on welfare.
Mr. Speaker, I've never heard such a foolish statement in my life in the legislature. As a matter of fact, Mr. Speaker, there is nobody in Canada that does more to help their farming population or young farmers than this government does.
Vegreville.
Supplementary to the Associate Minister of Agriculture, given the fact that the ADC now holds title to 800 quarter sections of land, and her report muses about restructuring another 2,200 quarter sections of land, I'm wondering when the Minister is going to recognize that we've got a crisis in rural Alberta and that it's going to demand some thoughtful action immediately.
Mr. Speaker, I recognize that there are some stressful situations in agriculture. I also recognize that they do take some thoughtful responses, and that's one of the reasons that we're taking such care in deciding on what those responses will be.
Thank you. Edmonton Mill Woods, followed by Edmonton Meadowlark, then Athabasca Lac La Biche, and then Edmonton Beverly.
Mr. Speaker, at the weekend, the delegates to the Conservative Party convention voted overwhelmingly by a margin of some 10-1 to request the government to introduce so-called right-to-work legislation. That is legislation that would eliminate RAND formula dues checkoffs and you closed union shops. My question to the Minister of Labour, will he take this opportunity to renounce this kind of regressive legislation and indicate clearly to the working people of this province that his government has no intention whatsoever of introducing so-called right-to-work legislation in Alberta?
Mr. Speaker, the situation in Alberta is that there are really only 2 situations where one could say there is a legislative closed shop. One is with the employees of the government itself, and the other is in the teaching profession, where, of course, the Alberta Teachers Association is the professional body as well as being a union. Other than that, there is no requirement in legislation in this province for a closed shop, and they may well be negotiated between the employer and the union representing the employees, but that's a matter of civil contract that should not be interfered with by this government.
Supplementary to the Minister, could the Minister advise the House and table for us if he has any research before him that would indicate any value to so-called right-to-work legislation or any effects of such legislation other than lower rates of pay for workers and more hazardous and dangerous working conditions?
Perhaps the honourable member could do his own research.
Mr. Speaker, the Minister must be aware, I'm sure, and given that he is aware of the shameful record of labour legislation in jurisdictions in the U.S., can he not give us today his assurance publicly, say no to so-called right-to-work legislation and no to Alabama North here in Alberta?
Mr. Speaker, I think the member's forgetting this is a provincial parliament, and it's in Canada, it is not in the United States of America. I have no responsibility for what happens in Alabama, nor even in Saskatchewan.
This is the free trade government, Mr. Speaker. Mr. Speaker, will the Minister now admit that this so-called flirting with right-to-work legislation is simply another indication that his government gets its labour policy from the Pocklington faction of his party?
Getting weird.
Mr. Speaker, I'm not a flirtatious person by nature. We have had a very thorough review of labour legislation in this province over the last 18 months to 2 years, more thorough than any other government in Canada has ever indulged in. And if the honourable member likes to wait just a few more days, he will be able to see the results of all that consultation with Albertans.
Edmonton Goldbar.
Thanks, Mr. Speaker. To the Minister, when will the Minister introduce the Labour bill so that Albertans finally will know what this government is up to?
Answered it.
Perhaps, Mr. Speaker, the honourable member should visit the physician. It will be covered by health care, and see if her ears need unplugging. I just answered that question.
Edmonton Meadowlark, followed by Athabasca Laklabish.
Thank you. Thank you, Mr. Speaker. Mr. Speaker, my question is to the Premier. Alberta Government Telephone states clearly in its recent annual report that its priority is to be more competitive with the private sector. On the other hand, this weekend, the Progressive Conservative Convention stated that Crown corporations should be privatized. To the Premier, is it this government's policy that Crown corporations should, in fact, become more competitive with the private sector?
Mr. Speaker, I must say I'm thrilled that both opposition parties are hanging on the results of the very successful, most successful. Most successful provincial convention in the history of Alberta, and that the honourable members were so wrapped up. I invite them to come and join, and they can actually participate.
See the way. Meanwhile, back at AGT.
And participate, Mr. Speaker, in the discussions. And then they wouldn't have to ask questions here. My colleague, the Minister of in charge of telephones, will want to deal with this, Mr. Speaker. I would just say one more thing about the convention, because the honourable member raised the convention, Mr. Speaker, the annual meeting. It gave me a chance to point out to our party that our nominating meeting in Youngstown was larger than if you added up the annual meetings of both these parties together.
Supplementary question, perhaps, to the Minister of Transportation and
I'm continuing to pursue my line of questioning with the Premier. This is not a frivolous exercise, Mr. Premier. The fact of the matter is that AGT is emphasizing competition with the small business sector and undermining the ability for small businesses to create and develop in this province. Could the Premier please clarify what his philosophy is, what his government's philosophy is about private Crown Corporation competition with the private sector?
Mr. Speaker, if I can respond to the honourable member in the question of competition. The Alberta Government Telephones has a responsibility to be competitive in an industry which is shifting from one of a high level of government regulation and monopoly to one of competition. At the same time, we're trying to be very careful to remove AGT from certain areas where there is a good infrastructure of competitive capability by small firms in Alberta. One of those areas is the area of supply of acoustical equipment in halls and hospitals and schools and that sort of thing. And there has been a policy shift there to recognize that there is a good capability already existing in the province. The same thing is occurring in some of the attachments to telephones, but I have to advise the legislature this is a more difficult area because there are some very large international firms also supplying and doing so in a very competitive way in Alberta in this particular area, as they are in the rest of Canada for that matter.
AGT is still selling computers. Back to the Premier, because this is a philosophical question. Is the Premier accepting, this is a question of how government should relate to the private sector. Is the Premier then accepting the statement by his minister which infers that taxpayers' money is being used to undermine the activity of taxpayers, in this case small business people who can't compete with subsidized Crown enterprise?
Mr. Speaker, philosophical, small business people? Did you mean in height? Mr. Speaker, the Minister of Telephones will want to respond.
Mr. Speaker, on the matter of computers, the direction of telecommunications is that as part of the communication system now is computer installation and the processing and manipulation of databases on a very extensive, in a very extensive manner. And Alberta Government Telephones is involved, if you will, in computers because every switch that's manufactured now is in fact a computer. And that is the case with many of the consoles in offices and whatnot. So to meet the requirements of businesses, some of whom are linking a variety of offices through one installation, there is competition in that area, and I appreciate it. On the other hand, there is also an area of freestanding, if you will, personal computers, which, as far as I am aware, AGT is withdrawing from.
This question has broad implications for this party's stated policy to privatize Crown corporations. Could the Premier please indicate to the legislature upon what basis he will determine which Crown corporations or which parts of Crown corporations will be privatized and which won't be? Upon what basis should government be involved in Crown enterprise, and upon what basis shouldn't it be involved in Crown enterprise?
Mr. Speaker, these are matters of judgment, and normally the government would be governed by this kind of thinking, that if these things can be done by the private sector, that's where we'd like them to be done. If there is things that the province, the people of Alberta needs, and the private sector is either unwilling or unable to do it, and we feel that in the public interest it has to be done, then the government would get involved.
Calgary Fish Creek, followed by St. Albert.
Thank you, Mr. Speaker. The question and supplementals from the member for Meadowlark have to do with AGT's competitive sale of equipment in the marketplace. I wonder, Mr. Speaker, if I could, by way of a supplemental, ask the same minister to comment on the leasing side of AGT's behavior in the marketplace. And that is, would the minister be prepared to comment on the appropriateness of the leasing rates presently used by AGT, which are nearly half those that can be offered by private sector competitors?
Mr. Speaker, the questions which we've been discussing in the last few minutes are ones which come to my attention from time to time, and the question of the lease rates has been brought to my attention by the honourable member for Calgary Fish Creek, and I have taken it up with the Alberta government telephones. I do not want, and I think it should be, for that matter, do not believe it is the policy of the Commission to have staff of the Commission engaging in business practice which is a non-commercial, which may be at a non-commercial rate or manner. And I have accordingly taken complaints as I receive them to the Commission with that in mind. I may also advise all honourable members that since I have been minister in the last almost 2 years, I have twice, I believe it is now, had discussions of a general philosophical nature with the Commission so that we would have a mutual understanding of this area and the intent of the Commission and of the kind of general direction that the staff would be receiving. It is an area of judgment, however, and I've come to appreciate that more and more as I've received questions about it. The whole area of telecommunications is a very dynamic one, changing very rapidly because of technology. And on the one hand, I'm getting complaints from companies from time to time who want the services that only very large corporations can provide on a tied-together basis, a systems basis. On the other hand, the corporation, I think, must be sensitive and responsive to the need to back away from some of the areas that they had been engaging in earlier on.
St. Albert.
Supplementary, Mr. Speaker, to the Minister of Telecommunications. Since we're talking about privatization of Crown corporations, one of them being Alberta Government Telephones, could the Minister indicate whether there's any truth to this, that the Alberta Government Telephones is laying off and offering early retirement to some of their employees and then turning around and hiring those people back as consultants? Is that part and parcel of the move to privatize Alberta Government Telephones?
Mr. Speaker, I've had occasion, as the honourable member obviously has, to follow the news story and to pursue some of the detail, and I think I'm in a position now to assure the House that there were roughly, I believe, 11 persons who may have been re-engaged by Alberta Government Telephones, and I think 7 of them in one area since taking early retirement. That is contrary to the policy involved in early retirement. It is also, however, not a very material impact upon the total employment question. In other words, the numbers are pretty small. The direction of Alberta Government Telephones in connection with the individual line service area has been to contract, and I believe that of the 11 cases that I mentioned to the knowledge of Alberta Government Telephones, there may be 4 or 5 people who have indirectly gotten employment by appearing on the payroll of a subcontractor to Alberta Government Telephones. Now that's based upon the quick check that was made, but I do not believe that that the story as I have seen it, Mr. Speaker, represents the situation in a fair way at all in terms of what's happened. I think it's been a very minor involvement and one which Alberta...
Order. Thank you, Honourable Minister. May we move on to Athabasca Lac-La-Biche.
Thank you, Mr. Speaker. To the Minister of Transportation, during the past year, many small Alberta trucking firms have complained about the Department of Transportation by gouging by the Department of Transportation. Your department has dramatically increased vehicle licensing fee from about $1,200 to $1,400 a year, and instituted a new $50 annual permit fee. Now, since many diversified small trucking firms require up to 18 of these trucking permits, An additional $900 a year is added to their cost. Is the minister aware that these dramatic tax and permit increases have resulted in economic hardship for many small, diversified trucking firms in Alberta?
Mr. Speaker, the question should properly be addressed to the Solicitor General, and he's not here at the moment, but I think it should be passed on to him for a response.
Anyone?
Okay. An acting amendment. Takers notice for the supplementary questions that might be directed to another minister.
Yes, I can direct this following question to the minister. Is the minister received complaints from truckers relating to trucking industry relating to the excessive fee increases by the department? Has that been a concern expressed to you?
Speaker, I should point out that I haven't had any direct complaints raised with me. However, having said that, I'm not the minister responsible.
Would the minister agree that economic hardship created by transportation deregulation and by dramatic fee increases is resulting in many trucks being driven overloaded and with unsafe brakes and tires in Alberta highways?
Take that one as notice, Mr. Speaker.
The minister, I believe, is able to answer this question relating to deregulation and the hardship relating to the transportation industry because it is in his department. Now, with the minister in reports of hundreds of trucks being driven in Alberta highways that are unsafe, is he looking at implementing stricter type of supervision of these regulations?
Mr. Speaker, I can probably come closer to answering that one in the sense that I would ask first that if he has some information to provide to me of hundreds of trucks that are unsafe, I'd be more than happy to pursue that particular number with the Motor Transport Services people. Our combination, when we put together the Motor Transport Services Board and the Highway Patrol people, actually increased the number of inspections of vehicles on the roads in Alberta today, and we have a much safer situation than we had previously.
Edmonton Meadowlark supplementary.
To the Minister of Transportation, Mr. Speaker, has the minister undertaken to study the effects of deregulation on the small trucker in this province?
Mr. Speaker, Alberta has been a leader in the sense of deregulation, and particularly the fact that in the province itself we have been probably the only province up till the new deregulation across Canada has come into effect as being the leader. And we certainly have been working with the industry from day one, and with their support and with their insistence that we pursue and continue to pursue the ability to put in place regulations that would meet all of the safety standards and the like, plus the fact on length and weights and the likes of that, so that a trucker in essence can drive from Halifax to Vancouver through the province of Alberta and all of the other provinces without all of the permitting that had to be done previously. So it has been done primarily with the support of the trucking industry.
Chair recognizes Edmonton Beverly.
Thank you, Mr. Speaker. My questions are to the Attorney General. In December 1986, the Alberta Gaming Commission conducted public hearings relative to an application by the Edmonton Casino Association, which is the consortium of community leagues and charitable organizations, to operate a casino in the Edmonton Convention Centre. Will the Attorney General indicate to the Assembly as to which month the Edmonton Casino Association can expect a decision on the hearings of the Alberta Gaming Commission?
Mr. Speaker, the Gaming Commission, of course, is a body which is established by law in this province, and members are appointed by Executive Council. They have held hearings with respect to the application mentioned by the Honourable Member for Edmonton Beverly. It is a difficult decision that they are faced with. I would not want to try and make the decision for them because what is being asked in many respects is that 160 or 170, I'm not sure of the exact number, of organizations be given a large facility for their exclusive use when there are over 400 licensed
organizations, approved and licensed organizations in Edmonton, who are competing for the same type of casino licenses. So it is a difficult decision for them to make, and the honourable member may wish to refer as well to the remarks I made during my estimates of the Department of the Attorney General relative to my concerns for the issue of increasing casino operations in Alberta to the extent requested. But that it is a difficult decision. I can't give an answer to the honourable member as to the timing, but I do take this opportunity to point out that it is indeed a matter under serious consideration by the Gaming Commission at the present time.
Time for question period has expired. Might we have unanimous consent to finish this series of questions? Opposed? Honourable Member Edmonton Beverly.
Thank you, Mr. Speaker. In the estimates statements, the Attorney General did make reference to the application of a Calgary organization as well. And I'm wondering why the Gaming Commission is reviewing the two applications simultaneously, given the fact that each application is quite different in their sponsorship.
Mr. Speaker, the basic issue remains the same, both for the Calgary request and for the Edmonton request, and that basic issue is whether or not to permit what are known as upscale or larger scale casino operations. And the Commission is reviewing the impact that the granting of those upscale or larger scale casino operations would have on the several hundred smaller casino operations that take place now on behalf of religious and charitable organizations who are permanently licensed, or presently, not permanently, but presently licensed by the Commission under the existing regulations.
Well, since the Edmonton Casino Association made their application, a license to another local organization has in fact been granted. Why is the Edmonton Casino Association being ignored, or seems to have, or someone else seems to have more favor over this association?
Mr. Speaker, there are many organizations which receive licensing from the Gaming Commission. They have not ceased to approve qualified charitable, religious, and community organizations. That just adds, in some respects, to the concerns, of course, as new approved organizations come forward, that by granting exclusive rights for large upscale casinos operations to either a group in Edmonton or two organizations in Calgary, as the impact it would have on the several hundred other organizations who rely at some extent for their casino profits for the operation of their or for their benefits of the community, really, through their organizations. I just want to say, Mr. Speaker, that it is a matter of considerable concern, and I have been advised that the Commission is considering other alternatives so that the sharing of the opportunities to raise money through this means can be made available to the widest possible number of eligible organizations in the province. So it is not an easy question, and the Commission is, of course, taking some time to wrestle with it.
Thank you, Mr. Speaker. Well, to the Attorney General, the fact that these 170 or so groups or community leagues and charitable organizations that are withdrawing from the existing locations where they hold their casinos now into a new location would then open up the opportunity for the other groups to get into the older location. It seems to me this would work to resolve the problem for the community leagues and also those that wish to get into the casino activities.
Well, the honourable member is suggesting a solution which he might wish to advance to the Gaming Commission for their consideration. But the Gaming Commission has, as I have indicated, taken under consideration some other alternatives to try and meet the demand for casino operations. You must keep in mind this, Mr. Speaker, at the present time, the size of casino operations is kept quite small in terms of the number of tables and so on. What is being asked for is a major policy change to permit the creation of upscale or larger size casino operations. I expressed in my estimates concern for the development of that practice within Alberta that is not at the present time the policy of the Gaming Commission to permit these large, permanent, upscale casino operations. And there are many implications associated with the outcome of such a decision, not just the impact that it would have on the hundreds of licensed.
Thank you, Honourable. Additional supplementaries? Any other quarter of the House? Thank you. Member for Lethbridge West.
Mr. Speaker, to the Attorney General, based on the last annual report tabled in the House by the Alberta Gaming Commission, gaming has exceeded $875 million in Alberta, including $165 million in bingos alone, and that does not, of course, include the lotteries, which are a pretty prospering business. In view of those statistics, Mr. Speaker, would the Attorney General either give consideration or consider giving consideration to the Alberta Gaming Commission to perhaps have them do a review of all gaming activities in Alberta based on the fact that the Criminal Code of Canada states that only charitable and religious organizations may indeed carry out gaming activities?
Well, Mr. Speaker, that is part of the mandate of the Gaming Commission at the present time, and to make decisions with respect to this matter. And I agree with the honourable member that it does represent a considerable amount of money being expended by Albertans on one area of gaming, only one area of gaming, under the control of the Gaming Commission. And it is a matter that they must consider. And of course, from time to time, I expect that I will receive recommendations from the Gaming Commission relative to policy, and when those recommendations are received, they will be carefully considered not only by the Department of the Attorney General, but by the government itself.
Points of order. Leader of the Opposition.
Mr. Speaker, I'd under standing orders under, I believe you rolled some of the questions out of order under section 23.2, 23.1 actually, and 2 of the sub judice rule. Mr. Speaker, what we're dealing with here, Mr. Speaker, is a public document dealing with public policy. The fact is that the government has acknowledged that it is now a public document, and specifically we're dealing with a public policy. As I say under the sub judice rule, Mr. Speaker, it says where any person may be prejudiced in such a matter by the reference. What we were asking very clearly, Mr. Speaker, is what the government, why they didn't do something. It's not prejudicing anybody, Mr. Speaker, other than the government, which is not a person. And we're trying to find out from a public document that's been made public why this government in government policy didn't do anything about the situation. Now, Mr. Speaker, in the case today, even more so under the Trustee Act, we're dealing with the First Investors Corporation, and I might point out that they still remain on the list for investments under the Trustee Act. This is still true today, Mr. Speaker. It has nothing to do with the code inquiry. And Mr. Speaker, we've tried to look at this and taking in the rules that you made in regard to sub judice in the fall to basically ask questions very carefully under that direction. And we have not changed that, Mr. Speaker. We understand we're not asking about personal things that have occurred out of the code inquiry. What we've tried to do is specifically stay with government policy and why the government wasn't doing anything, Mr. Speaker. Now, I acknowledge, and as I said the other day, Mr. Speaker, which is true in any question period, whether it be under sub judice or not, the government does not have to answer the questions. And I appreciate that that's a fact under our British parliamentary democracy. But I say when something is clearly when we're asking
Government policy on a public document, Mr. Speaker, I don't know what could be more clear about what questions opposition should be asking in this legislative assembly, Mr. Speaker. And I point out that if we were allowed to continue whenever there was some government policy in some court or somewhere else, it would almost make question period totally impossible, Mr. Speaker, because I'm sure somewhere along the line there's a court case dealing with the government. But I want to make the case we're not trying to prejudice any individual person, Mr. Speaker. What we're dealing with is strictly a government document and government policy, and that's been the thrust of the questions throughout the last 3 or 4 days.
Member for Edmonton Strathcona.
Thank you, Mr. Speaker. I think there are two main points to be made on this admittedly thorny problem for you as Speaker, Mr. Speaker. The first is that the document of the sort we're talking about here is not a matter in dispute. It figures in a matter in dispute, of course, but it is simply a brick, as it were, building an edifice. And there's no dispute that it's genuine or not, for example. That's about the only dispute there could be. It's admittedly a government document. And the questions that are being asked about it simply ask why the government didn't act in accordance with the document or make certain other conclusions, reasonable or unreasonable, it matters not, based on the document. But that it is a matter in dispute is not true, Mr. Speaker, because the document is there and is admitted to be true. The second main point to be made is that in any event, even if it is a matter even if it can figure as being a matter in dispute, it is not within the terms of the standing order. It's 23G. A member will be called to order by Mr. Speaker if that member refers to any matter that is pending in a court or before a judge for judicial determination, or that it is before any quasi-judicial, administrative or investigative body. Well, the code inquiry is pending is a matter that's pending ultimately in court because depending on what Mr. Code rules, so the judge will make an order eventually. And it is true that Mr. Code exercises an investigative function. But the fact is, Mr. Speaker, that this is an investigation, as our party has been complaining about from the start, under Section 223 of the Business Corporations Act, and that section says that a security holder may apply to the court for an order directing an investigation to be made of the corporation and any of its affiliated corporations, not the government. So that, as a matter of law, it cannot be a matter in which the government is under investigation or that the judge can properly find either in favor of or against the government. Things may crop up along the way that are useful in considering the government's action, but it is not within the remit of the court. And Section 224 sets out all the orders that the judge can make, and it doesn't mention anything about the government in any of them. And therefore, it's not a matter that is under consideration the government. The other point to be noticed is that so far as Mr. Code is concerned, his is not a body within the meaning of the section. A body is a body of persons, such as some investigative commission or bodies that can hold inquiries, such as the Liquor Control Board, Securities Commission, Human Rights Commission, and so on. But it clearly is not a person, which is what Mr. Code is. And in fact, earlier in the same standing order, there is a reference to person, and by an ordinary rule of interpretation, if in the course of a few lines you change the term from person to something else, it's presumed that there is a meaning, a change of meaning intended. And therefore, for all those reasons, with the greatest respect, Mr. Speaker, when reference is made to a piece of evidence that's uncontroverted or even accepted, as this is clearly, in the Code inquiry, it cannot feature as being something against the rule. I suppose I should add, agreeing with my leader, that in any event, the government cannot be a person that could be prejudiced by any of this, even if all of what I say is wrong, where any person may be prejudiced in such matter by the reference. Now, the government cannot be a person within the meaning of that standing order, Mr. Speaker. If it were so, then there are some 500 pieces of evidence or more currently before Mr. Code, and I dare say that if you went through all those pieces of evidence, some of which are extremely lengthy, it would cover about 60% of all government business that we're doing in this Assembly, all, if your ruling is correct, Mr. Speaker, contrary to the sub judice rule as so interpreted.
Speaker, I'm really not impressed by the arguments of the honourable member from Edmonton Strathcona, who with length tries to achieve what brevity and precision would fail to achieve. Mr. Speaker, I draw the attention of all honourable members to the standing orders of the Assembly, and in particular to Section 23, which there has been reference, and it says very clearly a member will be called to order by the Speaker if that member refers to any matter that is before any quasi-judicial, administrative, or investigative body constituted by the Assembly or by or under the authority of an act of the legislature. Now, surely the business corp... all right, where any person may be prejudiced in such matter by the reference. We should finish it. It's important to have finished it, as a matter of fact. But my point is this. First of all, clearly the Business Corporations Act, under which the Code Inquiry is constituted, is under an act of this Assembly. And I surely would hope that the honourable member for Edmonton Strathcona won't debate that. So that now we get to the question of whether it's a quasi-judicial inquiry or an investigative inquiry. And surely it is, and the honourable member for Edmonton Strathcona just now acknowledges that. And the question is whether any person may be prejudiced in such matter by such reference. Now that's clearly the unknown of the inquiry. Surely it is. The inquiry process is to determine exactly what went on with the principal company, corporation, and all the matters that related to the problems before the company. The honourable member for Edmonton Strathcona, in his debate, said, and I quote, "The document figures in the dispute. It figures as a brick in building the edifice around the dispute." Now, if that doesn't constitute clear relevance to the possible prejudicial nature of any document, and he is saying it, the honourable member opposite is saying it is this document, he is clearly destroying his own case when he makes that argument. Although he did it in a long-winded, roundabout way, nonetheless, the fact is there that by his own evidence in argument, he has undermined the case he's clearly tried to make. He has said, all we want to know is why the government did or didn't follow the advice given in the document. Well, to say that's the objective of the opposition in posing the question, having said already that the document is very germane and important to the dispute, and figures as a brick in building the case, he surely, Mr. Speaker, has made his own argument of why the question should not in the first instance have been asked, let alone by any stretch answered. He further went on, Mr. Speaker, and on this I rest my
Division would like to get in debate later, that's quite fine, but not at this moment. Not at this moment.
I'm not long-winded, Mr. Speaker. It's the interventions and other calls that are causing the thing to spin out. I rest my case with the final comment that the honourable member for Edmonton Strathcona, in raising the question of whether this is quasi-judicial, says and acknowledges it is, because he says so the judge will make an order eventually based upon the findings. So he clearly makes it into a judicial case. He's destroyed every one of the arguments that have been advanced here, and Mr. Speaker, I submit, has clearly indicated, cutting through the verbiage, why your ruling should stand.
I simply wanted to add to the discussion of the point of order raised by the Honourable Leader of the Opposition. I think the fundamental arguments have been made with respect to the citations in our guidelines for the operation of the Legislative Assembly about what needs to be put on the table in terms of facts which have not yet been specifically moved. I deal with the letter itself and the gentleman, Mr. Darwish, Mr. Speaker. I think the member from Strathcona has properly noted, and I think is quoting from Mr. Justice Berger's judgment when he said that Mr. Code is acting as an investigator, not a recorder, and we all know full well that Mr. Code will be making a report to the court. In making that report, Mr. Speaker, reading again from Mr. Berger's judgment, it states on page 24 that Mr. Code must, of necessity, disclose clearly and unequivocally the inspector's view of how the various findings of fact relate specifically to the matters under investigation. The reason that I draw the attention of the Assembly and you, Mr. Speaker, to that note is that I want the record to show two things. First of all, that along with a lot of other documents that the government has made available to the Code Inquiry, this specific letter itself is one of those documents, which is now of a matter of public record before Mr. Code. And so in terms of evidential support for Mr. Code's decision, this document itself is an important one. We agree to that. Secondly, it should be noted, Mr. Speaker, that along with at least 21 other witnesses on the so-called government side of the investigation, that Mr. Darwish will be called before Mr. Code to testify. So what we have here, Mr. Speaker, is the clear fact that this letter is now before Mr. Code. Mr. Darwish himself, the author of the letter, will be appearing to explain to Mr. Code his reasons for the letter and his opinion as to what was the situation at the time. And we have also seen that Mr. Code must evaluate clearly all the evidence, including these two fundamental testimonies, one of a written form, one of a verbal form, which I'm sure Mr. Darwish will provide, in Mr. Code's report to the court. No matter how you look at it, Mr. Speaker, this evidence in Mr. Darwish's testimony is clearly before the court and clearly ultra vires to this court at the present time.
Edmonton Highlands.
Mr. Speaker, to put all of this into very plain language, it seems to me what's good for the goose is good for the gander. We were able to discuss this issue in the fall sitting of the legislature. I think the government was actually interested in having this discussion aired in the fall sitting of the legislature. The Code Inquiry is not struck to monitor the government of Alberta. That is the role of elected officials in this assembly, whether they be government members or opposition members. The questions that have been put over the last few days in this assembly want to know what the government knew, especially what the government did about what it knew, and that is straightforward, plain within the rights of the Legislative Assembly, legalese and bureaucraties aside.
Edmonton Kingsway, followed by Calgary Mountain View.
Thank you, Mr. Speaker. I rise to take up the a point made by the member from Jasper Place. He followed the argument down to where we talked about where a person may be prejudiced in such matter by the reference, part of number 23, of the standing orders. It would seem to me that if that part of the statement is to apply, you would have to claim that the questions that we are raising in some way prejudices the rights the rights
of some of the contract holders, for example, or some people who had money involved in principal. The questions very clearly are aimed at asking the government about their policy. And the government is not a person, as my colleague from Strathcona said. And so how you can claim that any questions that were asked today or on the last several days for that matter on principle could in any way jeopardize any of the participants in that code inquiry or any of the people that have an interest in it other than the government, and the government is not a person, then I do not see. And so I think the member was quite wrong on the point he made there.
Calgary Mountain View.
Mr. Speaker, it's important for all members of the legislature to understand what the rules are, and I felt that this had been clarified in your ruling on this matter earlier last fall. And a number of the points that you made at that time were that it was, first of all, on the responsibility of the member asking the questions to ensure that they were not sub judice. Secondly, if the minister is to respond, it's also up to the minister to be able to interpret and declare to the House whether the matter is sub judice. It's not the number one functioning of the chair to become some sort of legal expert with regard to all the court cases that are going on within the land. So, Mr. Speaker, I felt that in essence you had left it up to the members of the Assembly to determine between themselves when these questions being asked were sub judice. Again, you also stated that November 23rd, 1987, repeated that. Again, the chair has to rely upon the member of the House asking the question as to whether or not it's sub judice, and to not try to bring the issue to the floor when the member knows full well that the matter is before the courts. So, Mr. Speaker, it was indeed surprising to me, having established in precedent the procedure for pursuing these matters in the Assembly, for you to rule the Leader of the Opposition out of order in terms of the questions he asked today. I should also be mentioned that as far as it seems to be ruled out of order because the matter is pending before the code inquiry. And presumably the argument is that because Mr. Code was appointed by a judge to carry out an inspection of matter is therefore pending in a court. Well, I think it's only sufficient to note, Mr. Speaker, that all those concerned, Mr. Code, Mr. Justice Berger, Mr. Trawick, the Ombudsman and others, have all agreed that Mr. Code's investigation cannot make findings regarding the actions of the government in this matter, that the actions of the government are beyond the scope of his investigation, save only as they might pertain to the actions of AIC and FIC. Now, in addition to that, Mr. Speaker, the Ombudsman has initiated his review of this in response to complaints brought to his attention. And Section 12(1)(a) of the Ombudsman Act reads in part, "Nothing in this Act authorizes the Ombudsman to investigate any decision, recommendation, act, or omission in respect of which there is under any Act a right of appeal or objection, or a right to apply for a review on the merits of the case to any court or to any tribunal constituted by or under any Act until after that right of appeal or objection or application has been exercised in the particular case, or until after the time prescribed for the exercise of that right has expired." Now, Mr. Speaker, the Ombudsman obviously feels that given this authority under his Act, he can investigate the actions of the government in this matter. He must also equally believe that no other avenue lies open to those who feel themselves aggrieved by these actions. So, in his opinion, simply by pursuing this investigation, not only is the matter not now pending in a court or before a judge by virtue of it being in front of the code inquiry, but it cannot be in future either. So if he's right, then obviously, Mr. Speaker, this is not a matter of sub judice, and that the and it's proper for questions to be asked. And if the Ombudsman is wrong, well, then one could presume that he's acting outside the authority of his own act. Given that he is proceeding, given that the provincial government has funded his review, provided funding especially for him to pursue this matter, it's our opinion that he's within the authority of his act, and obviously by virtue of that, this matter, by being before the code inquiry, could not be sub judice. Given that, Mr. Speaker, the Leader of the Opposition pursued the matter by asking questions now for the last number of days, and given that the previous decision on this matter is that it's up to the members to make that determination, based on precedent, Mr. Speaker, I would ask that the matter of point of order not be, that the Leader of the Opposition's point of order be upheld.
The Chair has listened with great care to the arguments being espoused today. There are indeed some interesting variations on a theme that has been sung more than once before in this chamber with regard to this issue. The difficulty of the issue is indeed quite considerable. The Chair has attempted not only last fall but in this last 2 weeks to try to give as much leeway and discretion as possible to all members of the House. Nevertheless, the Chair has indeed been very concerned that some of the questions or some of the commentary leading up to questions has been out of order. The other day, the Chair cited one instance of an honourable member who had, in the opinion of the Chair, unworthy as that may seem to be, nevertheless, in the opinion of the Chair, had violated the sub judice convention and had attributed blame to certain individuals. And that in itself raises concern for the Chair on behalf of the member that made the statement. That's an ongoing concern with respect to the House. With regard to the questions that are framed, once again, it's legitimate for the Chair to comment that the opening question can indeed have extra material in it, one or two carefully crafted sentences, but more and more the tradition of this House has become the fact that people feel that they can engage in a lot of back chat, repartee, and other comment even on the supplementary questions. And it's in some of those areas that some of the other variations start to take place, which lead members of the Assembly to think they're hearing something else, and then all of a sudden the twist of the tail is a different question. So that makes it difficult for all members of the House, and perhaps one could just simply attribute that to defined skills of debating technique. But the matter before the code inquiry, the matter before the Ombudsman investigation, the matter as raised today is of such a very serious nature that not only the Chair but all quarters of the House have to be very careful indeed about what is being asked or said within this chamber, because no matter the cogency of the argument or the embroidery of some of the arguments as to when is an inquiry and when isn't an inquiry, it is patently clear to the Chair that it is a legitimate inquiry both for Mr. Code and for the Ombudsman. Therefore, the sub judice rule does apply within terms of the not only standing orders, it applies also within the ambit of Beauchesne. It applies even further within the larger ambit, if you will, of Erskine-May. And in a moment or two, the Chair will refer to some of those documents. With regard to what transpired in question period today on the opening question by the Leader of the Opposition, the first question, having examined the blues, in the opinion of the Chair, is still clearly out of order. Nevertheless, questions were allowed to continue, and as pointed out by the Leader of the Opposition in his remarks, and examination of the blues confirms the fact that the chair allowed it to continue, that the other question about why was a certain company still listed was indeed a legitimate question to be posed, and that was indeed allowed to be posed by the Leader of the Opposition. So it strikes the chair that once again we're back into the situation of last fall, where the statement of the chair to the House was such that one of the ways to deal with the matter was to have all the questions written ahead of time, if that's what you choose to do. If the members do not want to go along with that, that's quite fine, I suppose. That's the individual decision of a member of this House to make. But then the individual member must be prepared for the fact being called for order. And whether the member then would want to challenge it at the end of question period would be, again, quite legitimate, able to transpire, and we will deal with it on a procedural basis daily. Chair is quite prepared to do that, quite prepared to sit here and listen to the argument. But there's the other avenue, of course, to put a written question for the order paper. That also was suggested last fall, was not really carried through with, and the chair can understand why there was some hesitancy to use that procedure, which is a procedure which is fixed in parliamentary democracy as being a way of being able to gain access to the information that an honourable member may wish to seek. That method would be one whereby we would not have to be using up great gobs of time in terms of the Assembly dealing with points of order. But once again, the chair is here to deal with whichever procedure transpires. The difficulty involved is a bit more complex than that, in the sense that the sub judice convention is there under our standing orders, and it very clearly states 23, a member shall be called to order by Mr. Speaker if that member G refers to any matter. It doesn't just simply ask a question or responds to a question, it's refers to any matter. So there we are back in terms of the preambles to the question. And then we have our subsections which have been quoted, but I do it again for the Hansard record. That is pending in a court or before a judge for judicial determination, or 2, that is before any quasi-judicial, administrative, or investigative body constituted by the Assembly, or by or under the authority of an act of the legislature where any person may be prejudiced in such matter by the reference. Now, for a while here, the argument was being made as to when is the government, when is an individual member of that government not a person, and along such lines, and is an interesting development of an argument. Nevertheless, within terms of the inquiry, it has been pointed out that the inquiry shall have the power to summon ministers of the Crown in right of the province of Alberta and their deputies and employees, and that is specifically set out. Again, it is put out, it is referred to, the matter as referred to Mr. Justice Berger. Dated September the 30th, 1987, the signature of Mr. Code, whereas the investigation section F, small section F, page 6, with generally the adequacy of the steps taken by the responsible departments of the Government of Alberta to assess and enforce compliance with the above-mentioned matters were the same as relevant to the mandate established by the aforesaid orders. The inquiry indeed has the scope and jurisdiction to be dealing with the government, not only as an entity, but dealing with the government in its individual ministers, those who have been called or will be called before the inquiry. The unusual step has been taken to remove parliamentary immunity for ministers of the Crown so that they might indeed appear before the inquiry. and therefore in their individual and collective right, they may indeed be prejudiced by comments made in this assembly or by their answers. So I believe that the whole matter is indeed still firmly sub judice. The chair also realizes that in the fall sitting that certain questions were allowed. The chair is still prepared to have the questions reviewed on an individual basis. Some questions which will indeed deal with present and future policy, but not questions dealing with what occurred in the past, matters which indeed will be before the inquiry if they have not already been there. The fact that the Honourable Leader of the Official Opposition continually refers to a public document, a document which has been apparently filed as evidence at the Code Inquiry, while the document is indeed public, the contents of which are available to a number, are open to a number of interpretations. With due respect, it is not up to the Leader of the Opposition or any other member of this House necessarily to follow up on the contents as to what exactly was meant by the documents and their interpretation. That begins to presume to intrude upon what the inquiry is about and has been charged to deal with in terms of its mandate. The Honourable Leader of the Official Opposition apparently believes that he has the right to ask the question, and however noble his motives are on behalf of parties involved, it is with respect the opinion of the chair that that is not the case, that he has the right to ask any question whatsoever. But as pointed out earlier, something that has to do with present and future policy, quite fine. But in terms of what had occurred during the time period in which the examination of these boards has to deal with, then in the opinion of the chair that that would not be legitimate, would not be in order, and therefore would be called to order. There are enough citations in Beauchesne where indeed it is the responsibility of the member raising the question, as well as the responsibility of the Minister of the Crown in making reply to know whether or not it is sub judice. In this particular matter, in spite of the reference by Calgary Mountain View that to the chair not being able to be expected to know all of the pending court cases in the province, nevertheless, it is sufficient for us to realize that the two inquiries now underway are indeed issues that call into play the sub judice convention. Once again, for the benefit of all members and for the Hansard record, the sub judice convention 335 applies. Members are expected to refrain from discussing members that are before the courts or tribunals, which are courts of record. The purpose of the sub judice convention is to protect the parties in a case awaiting or undergoing trial and persons who stand to be affected by the outcome of a judicial inquiry. It is a voluntary restraint imposed by the House upon itself in the interests of justice and fair play. Once again, in Beauchesne 339, Special Committee on the Rights and Immunities of Members recommended that the responsibility of the Speaker during the question period should be minimal as regards the sub judice convention, and that the responsibility should principally rest upon the member who asks the question and the minister to whom it is addressed. But if the matter persists, then the chair of necessity has to intervene because it is becoming such. We then have the other problem of repetition. There are other issues that could well be addressed in terms of the chair calling the House to order. Those references are there throughout Beauchesne. The references are there, indeed, for the operation of the House. One I would quote, 368 in Beauchesne. The Speaker, in common with his duties of supervision over the proceedings of the House, may rule out any question which violates the rules or practice of Parliament in the same way as he deals with irregularities in motions and amendments. And while the chair hesitates to have to use that, nevertheless the chair will use it. And we will find ourselves then having to make other references to other documents. So it is that also from Erskine May, page 445, it's under the title Minor Breaches of Order. When any member transgresses the rules of debate, otherwise than by using disorderly or unparliamentary expressions, or makes any noise or disturbance whilst another member is speaking, or commits any other breach of order or decorum not amounting to grossly disorderly conduct, it is the duty of the Speaker, if in his judgment the occasion demands it, to intervene and call the member to order or direct him to resume his seat. Now, the real problem still boils down to this. In the opinion of the chair, it's the responsibility of the member raising the question to keep the question perfectly in order. And the difficulty, as pointed out earlier, is some of the surrounding preamble to the question, which makes all members of the House have great difficulty, again, to be able to ascertain what the kernel of the question is. But until any other procedure is developed in this House, whether it can be taken up with House leaders of the various parties, the chair is most concerned about this attempt to get around the sub judice convention. And if indeed questions persist, then the chair will just keep calling them to order. And then the next question will have to be asked and go on and on from there. Excuse me. And on a daily basis, the chair will have to review after the fact, and points of order that are brought up will be dealt with on the day following, after the full record has had a chance to be carefully examined. The chair apologizes to the House, but the matter is of sufficient importance that the chair would also instruct all members of the House to perhaps reflect a bit more upon what the real importance of the parliamentary system is in this chamber.
Because frankly, I'm still not satisfied in terms of just asking.
I'm sorry, what came out as a point of order.
The point of order that I have, and I still don't understand where any person, where it says under section 23, I don't need to read through, but the last part of it, where it says where any person may be prejudiced in such a matter by the reference. Now, clearly, Mr. Speaker, that means in this case that there are investors, there are perhaps the people that own the companies. But I do not think in any sub judice rule anywhere that means having to deal with government policy.
That's right.
Mr. Speaker, I'd ask, as a clarification, that we look in that, because that's a very serious matter. If we're going to rule everything that's in court, no matter whether people are prejudiced or not, only the government, that somehow that's sub judice, I suggest that that has very severe implications in terms of what we do here. And I'm not asking for clarification at this point, but I'm asking if the Speaker would take a look in this, because I don't understand who's being prejudiced in this whole matter, Mr. Speaker.
Hear, hear.
Thank you, Honourable Member. I think for clarification, the Leader of the Opposition should read the comments as made by the Chair, because in that matter, the Chair did delineate the responsibility in terms of individual ministers, because they are indeed being brought before the inquiry and on a voluntary basis, and therefore they are indeed open to being prejudiced by the comments made in this chamber. I'm sorry?
Speaker, then can we follow that up? Would the Speaker take a look at this whole matter? I'm asking as a courtesy, because that's unusual, Mr. Speaker, that in terms of government, we're now delineating it to individual members of the government.
That's right.
We're asking about government policy. And if that's the ruling, Mr. Speaker, it's going to be very difficult to do anything where there's a court in any matter dealing with government, because then we're going to say individual members could be involved. So,
That's
Mr.
nonsense.
Speaker, rather than continue, it's not nonsense.
Follows on his ruling.
Because we're talking about government policy here, and if we're going to say because individual members, individual cabinet ministers are involved, they're prejudiced as individual members of government, Mr. Speaker, I suggest, with all due respect, that has implications far beyond what we're doing here today.
The Chair will first point out that this is the last point of order on this issue for this afternoon, before one has to get involved with another section of Beauchesne with regard to the relationship to the chair. But the chair also points out and brings again to the attention of all members of the House the unusual circumstance whereby the government have indeed removed the immunity of their ministers from having to appear before the inquiries, and they are now going to inquire, and it has been specifically referred to in the documentation, and therefore it makes for a rather unique situation.